What happens when someone fails to fulfill their promises or causes harm through carelessness? Understanding the difference between breach of contract and negligence is crucial for anyone involved in business or legal matters. Breach of contract and negligence represent two distinct legal claims that often confuse people. A breach of contract occurs when one party fails to fulfill obligations agreed upon in a contract. Negligence, on the other hand, involves a failure to exercise reasonable care that results in harm to another party, even without a contract between them. The fundamental difference lies in their origins. Breach of contract claims arise from agreements between specific parties. Negligence claims stem from a general duty of care that everyone owes to others in society. This distinction shapes how these cases are handled in court. Let's illustrate this with an example. Imagine Tom agrees to sell a car to Barry. Barry pays the agreed amount, but Tom gets drunk before delivering the car and crashes it. Tom has not only breached his contract with Barry by failing to deliver the car, but he also did so negligently by driving while intoxicated. This scenario demonstrates both breach of contract and negligence. Negligence isn't always straightforward. Courts consider whether a party failed to exercise reasonable care in fulfilling their obligations. For instance, if a software developer delivers poorly coded software that fails to function as intended, they could be liable for both breach of contract and negligence. When examining breach of contract, we look at whether a valid agreement existed if one party failed to meet the terms, and if this failure caused damage. The contract itself defines the obligations. For negligence, we must establish that one party owed a duty of care to another, breached that duty through carelessness, and directly caused foreseeable harm. In some situations, you can sue for both breach of contract and negligence simultaneously. This typically occurs when a professional fails to meet both contractual obligations and professional standards of care. For example, a doctor who provides substandard treatment may breach both their medical services contract and their professional duty of care. However, courts often prevent plaintiffs from recovering damages twice for the same injury. The economic loss rule generally limits recovery to contractual damages unless a separate duty of care exists outside the contract. When determining negligence, courts apply what's called the but for test of causation. They ask, would the damage have occurred but for the defendant's negligence? Consider a scenario where an asthmatic patient dies because a doctor leaves to say goodbye to his girlfriend. The question becomes, would the patient have had a chance to survive if the doctor hadn't negligently abandoned his post? Proving liability differs between these two claims. For breach of contract, you must show a valid contract existed, terms were clearly broken, and losses resulted. For negligence, you must demonstrate the defendant owed you a duty of care, breached that duty through carelessness, directly caused your injury, and the damage was reasonably foreseeable. To protect yourself from potential liability, consider these precautions. Always have a lawyer review contracts before signing. Include liability limitation clauses when possible. Thoroughly understand all contract terms to avoid misunderstandings. Obtain appropriate business insurance, particularly professional liability or errors and omissions coverage. Maintain compliance with industry standards and best practices. Breach of contract and negligence represent different pathways to legal accountability. One focuses on promises made and broken, while the other concerns reasonable care and its absence. Understanding these distinctions helps navigate the complex landscape of legal liability, whether you're seeking compensation for harm or protecting yourself from potential claims.